This is the third video on the topic of international responsibility of states. It focuses on circumstances precluding wrongfulness. In former videos, I have conceptualized the legal regime governing international responsibility in general international law as the customary rules that are codified by International Law Commission and endorsed by the United Nations General Assembly that establish the legal consequences associated to a breach of international law. I have then outlined the conditions that trigger international responsibility, explaining what constitutes an internationally wrongful act and when that act can be attributed to a state. For international responsibility to be triggered by the existence of an internationally wrongful act that can be attributed to a state, a third condition must be met. That is, there shouldn't be any circumstances that justify that behavior or that excuse that behavior. Circumstances precluding wrongfulness will prevent triggering the legal consequences associated to the violation of international law by a state. The circumstances precluding wrongfulness are codified in Articles 21 to 25 of the International Law Commission Articles on Responsibility of States for Internationally Wrongful Acts. The articles list as relevant circumstances precluding wrongfulness, which are consent, necessity, self-defense, countermeasures, force majeure, and distress. While the articles provide some content to the meaning of these concepts, especially regarding the controversial state of necessity, the articles are just listing here rules of international law that are already established in customary law. If these circumstances concur, the existence of an internationally wrongful act that is attributed to a state will not arise international responsibility. Before I explain succinctly the content of every one of these circumstances, I want to make a reference to Article 26 that reminds us that it is in the nature of the peremptory norms of international law that no circumstance can be invoked to breach them. So it is part of the definition of peremptory norm that no reason can be invoked to breach them. Despite the clear wording of Article 26 that proclaims in absolute terms that no circumstance can preclude the wrongfulness of the violation of a peremptory norm of international law, there is one clear exception. The use of armed force can be legal if there is consent, and in particular in the case of self-defense. There is a bit of complication on how this is justified with the issue of primary and secondary norms, but I don't want to enter into this discussion. That is a conceptual discussion, but has legal implications nonetheless, but in any case remains largely a theoretical discussion. What I want you to understand is that the main exception is the right to self-defense that operates as a justification to the use of armed force legally when the prohibition of the use of armed force is nonetheless considered itself a peremptory norm of international law. Whatever we agree or not with the categorization of the prohibition of the use of armed force as peremptory norm of international law, self-defense is the other side of the coin of the rule prohibiting armed force. The right of self-defense is inherent to the obligation not to use armed force. Precisely because the use of armed force is prohibited, you have the right to self-defense. In addition, states can consent to the use of armed force by another state in its own territory. However, it's inconceivable that states will consent to a use of armed force that will have themselves as a target. For instance, an agreement by which a state will agree that another state has the right to use armed force to enforce a treaty will be invalid. The issue of consent is always complicated when the legitimacy of the government providing the consent is disputed. or if the government has no control over the territory, either because it never had it or because it loses it. The legality of the use of armed force in self-defense or with the valid consent of the state is confirmed by the case law of the International Court of Justice in the cases of the armed activities in the territory of the Congo, the oil platform case, and the case on the military and paramilitary activities and against Nicaragua. I have made already reference to all these cases in past videos too. A second principle that's applicable to all circumstances precluding wrongfulness is that they do not terminate obligations. They prevent international responsibility to arise if they are present when the internationally wrongful act occurs. So a state breaches an international rule. However, there is a circumstance that exculpates, that justifies that behavior, but the obligation that was breached continues to exist. We can illustrate this using the case of the armed territories in the armed activities, in the territories of the Congo again. The conflict at the origin of the case involved the use of armed force by Uganda in the territory of the now Republic Democratic of Congo. In fact, the Democratic Republic of Congo had consented to the presence of the Ugandan troops in its eastern border. It consented during a period of time, but then the Democratic Republic of Congo removed that consent in 1998. While the consent was present as a circumstance precluding wrongfulness in this scenario, the presence of the Ugandan troops was not illegal. Once the Democratic Republic of Congo revoked the consent, the obligation of respecting the territorial integrity of the Democratic Republic of Congo and not to deploy armed forces in its territory was still in force. The consent did not end the obligation. Also, in the Gachikovo-Nagimaros project case between Hungary and Slovakia, Hungary tried to use a state of necessity as legal basis to terminate the treaty that obliged both parties to build a dam. The International Court of Justice reminded Hungary that even if a state of necessity had existed, this would not be the legal basis to terminate the treaty. The state of necessity in that scenario would justify that Hungary was not fulfilling its part in the completion of the dam, as it was prescribed by the treaty between Slovakia and Hungary, as long as the state of necessity remained relevant. Once it disappeared, the treaty is still in force. In that case, the treaty was still in force. This kind of logic also works at domestic level too. My presence in someone else's house is illegal unless that person has invited me to be in that house. So the consent, the invitation, makes my presence in someone else's house legal. But once the invitation is revoked, the obligation not to enter in other person's homes remain. The rule does not change once the consent is removed. I will address briefly each of the circumstances listed in the articles on international responsibility as advanced earlier. These circumstances are for the most part well-established customary law. I have already referred to consent and referred to the case of the armed activities in the territories of the Congo as relevant case law in this scenario. The main issues around consent relate to the legitimacy of the government providing it, particularly when more than one group claims to be the government of a particular territory. Within a government, there is also the question of who is the authorized official to provide consent. And finally, how do we prove the consent exists and that this becomes particularly tricky in international relations that remains for the most part characterized by confidentiality. For instance, and that's why I inserted there a picture of a drone, in the context of drone operations carried out by the United States in countries like Afghanistan, Somalia, Yemen, and Pakistan, the US has claimed that these operations were legal because they relied in the consent of the states in which these drone operations were carried out. However, this has not always been clear, particularly in the case of Pakistan, where different officials and members of the parliament have denied in several occasions that the consent existed. However, a clear statement from the Prime Minister addressed directly to the United States counterparts was not really public until 2013. In this scenario, in addition, the military seems to hold a lot of power, and it does not look like it's totally under the control of the civilian government. So there are questions on whether the US is acting nonetheless with the consent of the military, even if it has not got the consent of the civilian government. As you can see, in practice, it can be difficult to establish the validity of consent. I will just mention self-defense here, a topic we will address in the context of the international legal regime governing the use of armed force. States can adopt measures to react to a breach of international law by another state that affects them directly. To say it in the simplest possible way, when a state adopts sanctions against another state, these sanctions in international law are called countermeasures. However, it is not necessary for the countermeasure to relate exclusively to the reciprocal relationship to which they respond. For instance, imagine that Sri Lanka has an agreement with India, a treaty by which Sri Lankan fishermen can fish in Indian waters. In exchange, Sri Lanka allows some exploitation of its continental shelf by India. In my fictional scenario, if India prevents Sri Lankans from fishing in violation of that treaty, Sri Lankans can react with countermeasures that may or may not be related directly with that treaty. So Sri Lanka can stop Indians from exploiting its continental shelf, or they might decide another measure outside the confines of that treaty. For example, Sri Lanka may stop paying a debt they may have with India. However, countermeasures are more likely to meet the requirements of proportionality if they are taken in relation to the same or a closely related obligation. We call them countermeasures if they are acts that would be otherwise illegal. It will be illegal that Sri Lanka does not pay its debt with India, or that Sri Lanka doesn't allow Indians to exploit its continental shelf if they were not a countermeasure. They normally involve that the state adopting the countermeasure stop fulfilling a treaty obligation. They must be, as I said, justified, and they must be proportionate to the act they are responding to. They are also temporary measures with a specific end. When that end is achieved, the countermeasures cease to be justified. This again relates to Article 27 before, that underlines that the underlying obligation continues to exist. The proportionality test and the logic to which they respond requires that countermeasures are only applicable for rules that establish reciprocal obligations and not rules that protect collective interests. It is inconceivable that a state starts violating human rights of citizens as a response to the violation of human rights by another state. You cannot start violating human rights as a countermeasure for a breach of another state. The same is true for the protection of the environment, for example. Articles 49 to 53 of the Articles on State Responsibility elaborate further on this and other conditions that must be met by countermeasures to preclude wrongfulness. Article 23 regulates force majeure, and Article 24 regulates distress. Both refer to objective situations that oblige the state to breach an international rule. In the case of force majeure, there is no other option but to breach the rule. Imagine that a state is obliged to provide gas to another state, but an earthquake destroys the necessary infrastructure to that end. As a real example, in 2010 and 2011, volcanic ash from Iceland, a volcano that I cannot pronounce the name, but disrupted air travel considerably worldwide. This creates a basis to invoke a circumstance precluding wrongfulness, force majeure. However, when this kind of event happens, and causes harm, even if a force majeure exists to preclude responsibility, specific rules may still require to pay the damage, as we saw in the first session video addressing international responsibility. Contrary to force majeure, distress implies the possibility of not breaching the rule, but doing so will endanger lives. So the state can still fulfill the international obligation, but if it does, lives will be in danger. The typical example is a sinking boat that enters the territorial waters of another state to get shelter. In the context of the current pandemic, Federica Padot and Freya Jeffcoat have already argued that force majeure and distress might be claimed by states to mitigate or remove their international responsibility for unfulfilling their obligations, for instance, in delaying the completion of major investment projects. Finally, the Articles on International Responsibility contemplate the possibility of claiming a state of necessity as defense for the violation of an international obligation. This circumstance precluding wrongfulness is very controversial because here the state that is responsible for the internationally wrongful act tries to justify it on the basis of preserving an essential interest of the state, something vague enough and open enough to multiple interpretations. In the Gabčíkovo-Nagimaros case, the International Court of Justice did not accept this as a basis for terminating a treaty by Hungary, making clear the distinction between causes precluding wrongfulness and grounds to terminate a treaty. Again, this idea that even if a circumstance precluding wrongfulness exists, it is not a ground for terminating an obligation. The Rainbow Warrior case provides the typical example illustrating the controversial interpretation that can be associated to a state of necessity and other circumstances precluding wrongfulness. This is a case about two secret French agents that sink a Greenpeace ship that was named the Rainbow Warrior and was docked in the Auckland Harbour in New Zealand. The operation, carried out in 1985, had as main objective to prevent that Greenpeace could sabotage, disrupt the nuclear test that France was planning to carry out at the time. Let's say that the French sabotaged the saboteurs. It was not their intention, but in the course of this operation, they killed a member of the crew, a Dutch photographer, Fernando Pereira. This led to a dispute between New Zealand and France that was resolved by the then UN Secretary General Pérez de Cuéllar in 1986. As part of the agreement they reached, France had to expatriate the French agent to an island, for a number of years, 3 years, I think it was. Before that time was completed, France brought back to France the two agents violating the decision of the UN Secretary General. France argued that it had to repatriate the two agents based on medical reasons, and that these medical reasons amounted to force majeure. The arbitral panel in charge of resolving this dispute considered that the medical grounds were not enough to claim force majeure because France's obligations under the treaty was not rendered impossible. Therefore, it did not meet the standards that were later codified in Articles 23 and 24 reproduced above. The arbitration also concluded that no state of necessity could be invoked to preclude wrongfulness. While medical reasons may have justified the repatriation of the agents in a first moment, they should have been returned once the medical reason ceased to exist.